Hello, hope you're all doing well. Let me know you can all hear me. I've plugged in a microphone that I don't normally use because we're multiple streaming today. In about an hour's time, I will be live over on MichelleAfterDark to continue day 3 of the Leilani Simon trial. So I've got 2 computers on the go, so I've had to find a microphone that I haven't used for a while. So it looks like it's working. Good, people can hear me. That's great. Fantastic. That's a good start. So we're here to live stream the very last pre-trial motions hearing of Sarah Boone. So if you've been following the updates and the ongoing saga of the Sarah Boone trial, I've been updating in the breaks and the lunchtime of Leilani Simon. But for those that missed that, those that are not following Leilani's case on my channel over on MichelleAfterDark, then let me just summarize very quickly. So Sarah Boone's trial was meant to start last week, and actually jury selection did start last Monday. So not Monday just gone, the Monday before. However, due to Hurricane Milton, the judge made, I think, a very sensible decision to delay the trial for a week. So let Milton pass and then resume. So jury selection resumed on Monday, this Monday, and they are still in the throes of jury selection. They have not got through jury selection yet. And a bunch of motions came in that needed to be dealt with. So this morning over in Florida, there is the final pre-trial motions hearing, which is due to start in about 10 minutes. So you can see there I've got Law and Crime Network up, and I'm going to stream from Law and Crime Network because they seem to be the only channel that are streaming it. I'm sure there are others, but that's just the one that I found. So I'm going to be streaming from Law and Crime Network. You're very welcome to go and watch it over on Law and Crime Network. It's fine. It's fine. But yeah, that's due to start in about 10 minutes. So I don't know exactly what they're going to talk about. I don't know how long the hearing is going to be, but we shall wait and see. And then they're going to get back to jury selection. So jury selection is going to continue today and into tomorrow. Now, jury selection isn't televised. So as soon as the hearing ends, then the televising of the courtroom will end. I'll end the live stream over here. And by then, we will be live streaming over on MichelleAfterDark, Leilani Simon. Leilani Simon's trial is due to start at 10 a.m. today, 10 a.m. Eastern. And because of that delay, that half-hour delay that the judges has put in, it actually means that we only see it at 10:30 Eastern. So in about an hour, I'll be live over there, ready for the Leilani Simon Day 3 to start. All right. So the assuming that jury selection is done tomorrow, it's looking like opening statements for Sarah Boone will either start tomorrow afternoon or Friday. So we're playing it by ear, but as soon as that trial gets going, I will be streaming the entire trial gavel to gavel on this channel, Michelle Walks. So we'll have Leilani Simon on MichelleAfterDark, and we'll have Sarah Boone on this channel, right? Streaming at the same time. So they won't have breaks at the same time. I bet they don't have lunch at the same time. So I'll be able to chat to both audiences. So you can either choose the insane option, as I'm doing, to watch both trials at the same time, or you can flick between them, you know, as you see fit, or you can just watch one. If you're only interested in one, then just watch one. But I've got both covered. I've got both options covered for you. And then we've got Delphi. So Delphi is a televised. The judge is not allowing cameras in court. She's not relented on that. not even phones, nothing, right? So reporters can't live tweet. There is nothing. So what we're only getting is the things that people who were in the courtroom are telling us after the fact. So there were some bombshells yesterday, like really big bombshells in Delphi yesterday. I did a video over on Michelle After Dark this morning. I released it about an hour ago. Let me just show you this video right here. This video, not that one, this video. The entire case against Richard Allen. Delphi prosecutors' entire case against Richard Allen. What is left? What is left for this trial after the bombshells? So I did that update video over on Michelle After Dark. So go and check that out if you're following Delphi. There are some more Delphi things that I do want to talk about. So I will be talking about those over on Michelle After Dark in the breaks of Leilani Simon. So that will be all over on Michelle After Dark because it's going to be a long day. It was a long day yesterday. Lots of really bad audio from police interrogations. It was insane. It went on forever. I was live for almost 9 hours yesterday. That is the longest ever live stream I've done. So yeah, it's a lot. It's a lot, and there's lots of breaks, so there's lots of opportunities to catch up, to I guess recap the trial, recap the testimony, but also to talk about the other things that are going on, and particular what's going on in Delphi. So that will all be over on Michelle After Dark later on. So for this channel, right here, right now, we are just focusing on the Sarah Boone pre-trial motions hearing. Woohoo! I mean, this case, 4.5 years in the making. 4.5 years in the making. George Torres died in February of 2020. And the 9th attorney is actually sat beside her today in the courtroom. The 9th attorney, she sacked off, or they sacked her off 8 times, 8 different attorneys. And then Mr. Owens has jumped in at the 11th hour. And there was a very generous plea deal on the table. For those of you who saw what happened last Monday in court when they began jury selection, the prosecution offered her a very nice plea deal. 15 years. They were going to downgrade the charges from second-degree murder to manslaughter, and 15 years with the possibility of parole in much less time. So she's already served 4.5 years. She's been in jail since February of 2020. So she's got 4.5 years time served. And then if she's let out on parole, like let's say 50%, 60% of her sentence served in custody, and then she's let out on parole, she's only got a few more years to serve. So she's so confident. If you've seen the little clips of her in the courtroom, like the cameras are in the courtroom, they're just not allowed to televise jury selection. But, you know, they've televised little things, little snippets of her, like coming into court, having her shackles taken off. The nice outfit she had on yesterday. She had a really nice suit on yesterday. I thought the colour really suited her. She'd done her hair. The last thing we heard, though, last night was Sarah is hungry. Sarah's hungry. And she's hoping that the judge can order that the jail have got to allow her to have snacks at night. You know, because by the time she gets back to the jail after, you know, the day in court, commissary's closed. So she needs to be able to get her Pop-Tarts. She needs to be able to get her chips and her cookies. So, yeah, that's what the judge had to deal with. That Sarah is so confident that all she's got to worry about are the snacks. The snacks and the shower. The snacks in the shower, because the shower block closes at 9 and she's not back while 9. So can she have a shower? And yes, they are allowing her to have a shower, like after hours. So the jail are being very accommodating. So I hope the judge can fix, you know, Sarah's hunger problem, Sarah's snacks. I'm hoping that, you know, she's very full and she wants to have snacks at the council table as well. She hopes that the judge will allow that. I mean, I don't know. She's obviously got a sweet tooth. Maybe it's nerves. I don't think it is. She's all smiles. She's confident. She's confident. And in my opinion, she has not got a snowball's hope in hell of surviving this trial. Yeah, probably Dr. Pepper as well, Holly. Yeah, she loves her Dr. Pepper. We know she really loves her Dr. Pepper. So yeah, she wants the good life. She wants the good life. Well, you know, she's rejected the plea deal, so she's dealing with jail life as she means to go on, because she's going to be there a long time. I don't think there's any chance that she'll be found not guilty based on the evidence that the state have against her. Based on the video, you know, the George pleading with her to let him out. Pleading to let him out. But no. All right. Because I've not streamed on this channel for a long time, like Michelle Walks has just been laying dormant, I'm going to do a quick sound check. So there's no sound yet on Law and Crime. So let me just click on this video and just let me know that the sound's okay here. Good morning, everyone. My name is Michelle. I hope you're doing well. Welcome to another video. It is Wednesday morning, the 16th of October. So things have reached a crescendo, shall we say, in Delphi. Jury selection completed yesterday. So did you hear that all right? My video sounds good. Good. All right, good stuff. So we're over here on Law and Crime waiting. And I'll mute out once this hearing starts. It's due to start 9:30 Eastern, so any time now. There should be. I did see some reporters posting on Twitter before I went live saying that they'd not got into the courtroom yet, like the courtroom wasn't open yet. So maybe there is a small delay. Maybe Sarah's having to wait for her new clothes to be delivered. Maybe she wants a different suit every day. Maybe she's having hair extensions put in. Who knows? Sound is okay, a bit bassy. I don't know what I can do about that. I'm sorry. I don't know if I can. I don't think I can change the bass. Do you think she will testify? Apparently she is going to testify. Apparently she is. Yeah, apparently so. Unless she changes her mind, you know, it's her choice, you know, at the end of the day, but I'm confident that she will testify. She's testified at the last pre-trial motions hearing. She was there on the stand. The video is her downfall. It's not just the video, though. It's not just the video. It's what she said to the cops on the scene, the first responders, and it's what she said in the interrogation. She said, you know, I didn't mean to leave him in the suitcase. I fell asleep. You know, it was all just a terrible accident. And I could accept that. If she was really remorseful and really sorry for what she'd done, I could accept that she didn't mean it. It was a terrible accident. It was a joke that had gone wrong, and she genuinely passed out because she was drunk. She genuinely passed out. But she's so conceited and so arrogant. It's her entire personality that I object to. And that's why I can't have any sympathy with her. I just can't. And the domestic violence defense that she's going to try and use, yes, there was conflict in the relationship on both sides, both her and George. were aggressive when they were drinking. And both her and George were victims of that relationship conflict when they were drinking. They both filed police reports. But at the end of the day, you know, regardless of how much conflict there is in the relationship, any domestic violence that had happened in the past isn't relevant to this suitcase scenario, because she wasn't saying at the time to the cops that she was too scared to let him out. She wasn't scared of him at that time. It wasn't like, you know, she got him in the suitcase and she was too scared to let him out. There was none of that. And that would be the only way, surely, that you could use a domestic violence defense. So we'll see. We'll see. We will see. Yeah, she's infuriating. She's absolutely infuriating. She really is. She's not the kind of person who most people can get on with. And clearly, 8 attorneys couldn't get on with her. And it's their job. It's their job to represent, you know, troubled people, awkward people, people in the worst situation of their life, evil people, you know, all of those types of person attorneys have to deal with as part of their day-to-day business. But 8 attorneys could not get on with Sarah Boone. That says a lot. That says a lot. What time does it start? Anytime now. It's due 9:30 Eastern, so anytime now. We are waiting for court to begin. We're waiting for Law and Crime Network to start streaming. Let's refresh it. No, we're still waiting. So I can check Twitter to see if the reporters have actually got in the courtroom yet. Reporters on the scene here. Oh, it's making me want to sign in. I don't even know what. I've obviously never gone into Twitter on this account. I'll go on my other computer. I won't be able to put it on the screen, but I can't remember what my password is on Twitter. All right, let's have a look. Let's have a look. We've got some really heavy rain here, so if the internet glitches out for a second, then it's just the weather, and it will come straight back, so hopefully anyway. Oh, there we go. I did say I'm back. I did say we might glitch out. It's raining really hard. Let's have a look who's in there. All right, so Surviving the Survivor podcast is inside the courtroom. All right. Judge Kranick is hearing other cases. This is 10 minutes ago. So it's the judge. The judge is late. Then the motions hearing will begin. So there is a small delay because Judge Kranick is hearing other cases. Can't imagine that there'll be too much of a delay. He does seem quite an efficient guy, honestly. But then again, who knows? Yeah, the weather's horrible. I've got a pond in my backyard again. It had all cleared up. But we're back to ponds. Impromptu ponds. That's right, a man died because of her actions. Exactly. Or inaction. Inaction. She sat there and filmed him saying, Sarah, I can't breathe. And all she could respond to when he kept saying, Sarah, 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 I can't breathe, she was like, yeah, that's my name. Don't wear it out. That's my name. So that it's 100% her downfall. 100%. She is charged with second-degree murder, yeah. But I'm assuming that the jury will also be offered manslaughter. So if they don't feel that the state has met the burden for second-degree murder, I'm assuming that they'll have the option of manslaughter. There's another recent Florida case, if anybody watched the Ashley Benefield case. That was a Florida case. That was second-degree murder. And the state didn't meet the burden for second-degree murder, but they found her guilty of manslaughter. So I'm assuming that manslaughter will be on the table as a lesser charge. They usually have manslaughter on there as a lesser charge. And I would honestly, I wouldn't be upset if the jury found her guilty of manslaughter. I don't think she meant to kill him. I think it was an accident, you know, but it's the video. It's the video that has got her in this mess. And I think the jury hearing that video will be just as disgusted as everybody else. So she just looks evil. I think she's just very arrogant. She seems very arrogant. Like she knows better. She excels at everything, she told the cops. She excels at everything she does. So what she told the cops during the interrogation. Yeah, the video that she took. And obviously she must have been drunk because she'd even forgotten it was there. She didn't even know that video was there. That when the cops took her phone, she was like, oh, yeah, you can take my phone. And then they found the videos. Two videos, actually. I think we've only seen part. I don't think we've seen the entirety of those videos. But we've seen enough. She's very special, yeah. Straight A student, absolutely. Straight A student. High school genius. But yeah, here we are. She didn't do very well when she tried to represent herself. So she may need to revise the I excel at everything. She doesn't excel at being a lawyer. And why should she? Because she's not a trained lawyer. But she can no longer say that she excels at everything. So what can you do? What can you do? Nothing. She's delusional. Yeah. That Jill can't wait to get rid of her. Yeah, that's right. When she's convicted, she'll go to prison, won't she? So she'll lose the cushy life. Don't know what the state prisons are like in Florida. Who would get into a suitcase? Probably someone who was drunk and was larking about. Because I think he had to have got himself into that suitcase. I don't know how she could have put him in if he didn't want to go in. But then again, we've not seen the autopsy report. It could well be that he had injuries that we don't know about. You know, she could have cajoled him into the suitcase by I don't know, hitting him or something. But we don't know because we don't know the results of the autopsy. So that's one thing that we will find out at trial. Oh, absolutely. She's responsible. There's no one else. There's no one else that's responsible for George's death. Because even if he put himself into the suitcase, he couldn't have zipped it up all the way. She had to do the zipping. And then she was the one who refused to let him out when he said he couldn't get out and he couldn't breathe. So what are you to conclude other than, well, he died because of her inaction. And it's that inaction that has broken the law. He was knocked out and she thought he was dead. I don't know about that because he was talking. He was talking. Oh, yeah, we'll see the suitcase. The suitcase will be, the measurements and everything will all be presented. The actual suitcase will be presented as an exhibit. Still think she shoved the suitcase down the stairs. She may have done. She may have done because she certainly flipped it over, because in one video it's one way and then in the other video it's the other way. So she definitely flipped it over. And they were upstairs. The suitcase was upstairs. The hide and seek game, apparently, she went hiding upstairs. And then at some point shortly after that, he decided to get in the suitcase. So did they take the suitcase down the stairs before he got in? Or did he get into the suitcase upstairs and then she threw it down the stairs? She may well have threw it down the stairs and then been like tipping it, right side and upside, and just to torture him. And if there are other injuries, other than presumably he died of suffocation. So if there are other injuries that he sustained shortly before his death, I'm sure that the medical examiner will be able to determine that. And that also goes against her. We don't know for sure that she pushed him downstairs, but it's one speculation because the suitcase was upstairs. Like she said, the suitcase was upstairs. But what we don't know is was the suitcase brought downstairs before George got in? If George got in the suitcase upstairs, then yeah, she either dragged him or threw him down the stairs in the suitcase. She said the suitcase was downstairs prior to pack up her son's outgrown clothes for donation. Well, we don't know. We don't know. But they'll be able to ascertain whether or not an altercation happened that resulted in injuries to him, because he was found only a few hours after he died. So it's not like decomposition would have hidden anything. The entire events, if there was an altercation that resulted in injuries, all of that will be there for the medical examiner to report on. So we'll see. She put him in the suitcase on the 911 call. Let's see what she testifies to. I don't know how she could have put him in the suitcase, honestly. Like, if he didn't want to go in, how did she get him in? I don't really know. Yeah, judge is taking his time. $15 late now. No, he was definitely, he wasn't knocked out. He wasn't knocked out because he was saying, Sarah, I can't breathe. Sarah, let me out. You know, he wasn't knocked out. So there had to be at some level, he agreed to get in that suitcase. But that's not the point. That's not the point. The point is, once he wanted to be let out, she didn't let him out. She zipped him up to a point where he could not undo the zip from the inside. So if he can't undo the zip from the inside, the only other person who could let him out is Sarah, and she refused. So that's the point. That's where the law is broken. The law is broken at the point where she fails to assist him, and he dies because she failed to assist him. Yeah, she let him suffocate. She did. She did let him suffocate. She did. Absolutely, she did. So that's where the law is broken. And I just can't see how the jury are going to let her get away with it. I don't know. I don't know. Right, I'm going to try and get into Twitter on this computer. Okay. What do you mean incorrect? That's my name. He's telling me that my account name's wrong. It's not incorrect. Shut up. All right. Sign in. Oh, there we go. I'm in. Oh, there we go. I'm actually in. All right. There's some funny jokes on Twitter about Sarah Boone's snacks that we can have a look at. Is Sarah Boone late to court? No, the judges. I'm sure because Sarah Boone has no shame, she's already contemplating who will play her. I know I'm waiting for her to crack on a bag of chips at the defence table and start obnoxiously munching. Oh dear. Dear. So there are a few people streaming this. When will the judge rule on the battered spouse? Maybe today. I'm not really sure what this motions hearing is about. That's from yesterday. No, that's from Monday. That's what she was wearing on Monday. On the elevator up to the courtroom. Cool. So I think we're just waiting. We're just waiting. We do a lot of waiting when we're covering trials and hearings. These things never run on time. The judge in the Leilani Simon case isn't known for a good timekeeping either. Court TV said 2 p.m. but not on yet. So you mean 2 p.m. UK time? Yeah, well, it's nearly 3. Yeah, that juror that fell asleep in Leilani's trial yesterday. That's nuts. If he falls asleep again, I think they should just replace him with an alternate who can perhaps stay awake. Catch Me Up is Leilani's case taken the day after day. No, Pink Banjo. It's just an hour later than it normally is. There's something that they have to do before the trial can begin today. I don't know, something. So they told the jury to be there at 10 a.m. So we'll be going live over on Michelle After Dark in about half an hour, because 10 a.m. Eastern is in 7 minutes. However, if you remember, there's that half-hour delay on the live streams coming out of the courtroom. So it only starts 10:30 Eastern, our time, like for the public. Because what we're seeing in the courtroom happened half an hour previous. So I'll be going live in half an hour over on Michelle After Dark. So I'll be streaming this Sarah Boone on Michelle Walks here, right now. And then Leilani Simon on Michelle After Dark. So when the Sarah Boone trial starts proper, I'll be streaming 2 trials at the same time. Leilani Simon on Michelle After Dark and Sarah Boone on Michelle Walks. So that's what we're doing. There are some people who just fall asleep whenever they sit down. Father-in-law was one of them. Well, yeah, I can literally fall asleep anywhere. But if you're on a jury, you can't just fall asleep. So if that's your normal reaction to sitting down, with respect, you shouldn't be on a jury. Because you need to be attentive. You need to pay attention, because the small things matter. You know, you might fall asleep at the exact time when the most important evidence is being presented. The thing that could determine whether you believe that defendant is guilty or not guilty. So, no, you can't fall asleep when you're on a jury, even if you want to. So I'm not blaming the juror for falling asleep if he's got some kind of condition, or he's just that kind of person that it gets so relaxed that they fall asleep, but they should not be on a jury. I'm sorry, they should not be on a jury. Like someone with narcolepsy, something like that, you know, that's untreated, then they shouldn't be on a jury. Get rid of Sleepy and Dopey, yeah. Guarantee he'll do it again. Yeah, if that's something that he has a problem with, you know, when he gets comfy. And look, those seats that they give jurors, they're not comfy. It's not like they're given like reclining armchairs. They're not lounging about on couches. They're quite uncomfortable chairs. So I don't know. Maybe not slept well the night before. They should replace him. Yeah, I think if he does it again, they absolutely should replace him. Why? Why are we not started yet? Everything in this case is just delayed. Delay after delay after delay. Sadly, we can't get rid of Dopey because the defendant needs to be at the trial. Well, actually, they don't. They don't have to go if they don't want to. Think Adam Montgomery. He didn't go to his own trial. Couldn't face what he'd done. And even though he pled not guilty, couldn't face what he'd done, couldn't face the jury. So they found him guilty in his absence. But that's not Sarah Boone. Sarah Boone absolutely wants to be there. Loving it, she is. Have I heard of the what? H ghost controversy? No, I have no idea what you're talking about, Shaker Sister. No idea. The H ghost controversy. No. Sarah wouldn't miss this. She'd miss this for the world. She's loving it. She won't be loving it when she's found guilty. She'll be writing her appeal. This screen shows schedule for 2:30 though. Yeah, they're running late, Amber. They're running late. The judge is in another hearing. New video on plunder. I haven't watched it. All I've watched in relation to YouTube is Delphi. Because I live streamed for 9 hours yesterday. When I got off the live stream, I caught up with, what did I watch? Andrea Burkhart, I watched. Then I fell asleep. Then I woke up at some point in the middle of the night. I watched Defense Diaries. They were actually still live when I woke up, but I kind of replayed from the beginning. And then this morning I watched Lawyer Lee because they were all in the courtroom. So I wanted to see what they all had to say. So Reddit's all pedos and weirdos. It's not. There's some really interesting stuff on Reddit. Obviously, the subreddits I follow are not of that ilk. So she should have taken the deal. There's absolutely no reason why she shouldn't have taken that deal. The Reddit predator on Madeline Soto group is horrible. Oh, I don't follow any Madeline Soto groups on Reddit. To be honest, the only true crime I follow on Reddit is Delphi. Like Delphi Docs subreddit's good. And the Delphi Murders subreddit, that's a very pro-prosecution. But I do follow that one as well because I like to, see both sides. But I don't follow any other true crime subreddits. Reddit, I tend to read just random things. There's a really great subreddit called Spotted on Rightmove. So Rightmove is an estate agent website. So like it's the UK equivalent of Zillow. And there's people post up like really funny houses that they've seen, like really strange houses. That's funny. Mm. I think the other lawyers left because she was taking too many risks. I don't know why they all left, but I know why Bankowitz left. He left because she didn't like the expert that he'd recruited for the domestic violence defense. She didn't like the expert, and like she was basically obnoxious. So he said, "Look, I can't represent you then." And he'd actually got her almost to trial, Mr. Bankowitz. Was he number 6 or number 7? I lose count. But yeah, he'd really tried, Mr. Bankowitz. You love unusual houses. Yeah, there's some really good ones. Follow Spotted on Rightmove on Reddit. Overslept until 10 a.m. Well, I only got up at 9:30. Oh, we're up. We're up. That's an improvement. That's an improvement. Here we go. We don't have any sound yet. See? We don't have any sound yet. Oh, we got camera movement. Exciting. Yeah, I've got a really weird sleep pattern. So I woke up about 4, maybe, and was awake for about an hour and a half. Watched Defence Diaries, then went back to sleep till... Oh, here she comes. What's she wearing? Looking smart. Is it the same suit? No, it's different. Different suit, I think. Silver looks good on her, though, doesn't it? Silver chains. She's loving it. She is loving it. Look at her. She's so proud of herself. She's such a dweeb. Same suit, different blouse. You could be right. Like it was green. It was green. I like the shirt she was wearing yesterday. I like the colour. But yeah, I think you're right. It's the same jacket. She looks almost as smart as Koberger does when he walks into court. You know, jail suits some people. You have to admit. It really does. It suits some people. Koberger, he looks way healthier now than he did before he went into jail. It's nuts, really. A riding instructor. What do you think? She looks like a riding instructor. Yeah, I'll pass as well. But it just seems to suit some people. They look relaxed. Come on, Judge Kranick. Get your act together, son. Sarah Boone Esquire. Yeah, she's the lord of the manor. Sober and clear-headed, yeah. Suits her. If only she could have remained sober and clear-headed in February of 2020. Then we wouldn't be here. Which unlucky guy is her lawyer? Mr. Owens is the one sitting on Sarah's left. The one who's, I don't know, fidgeting about in his chair at the minute. That's Mr. Owens. Lawyer number 9. Lucky 9. I don't know who the guy on her right is. I don't know who he is. It's gonna be a crazy ride. The trial is, yeah. I mean, this pre-trial motion series, and I, like I said, I don't really know what it's about. I don't know what the aim is. Just to, I guess, just to clear anything outstanding that they need to do before the trial. All this last minute stuff often happens. Like a little flurry of new stuff comes out just before, like what's happening in Delphi right now. Literally buzzing. She is. She so is. It's a day in court, literally a day in court. Almost acting flirtatious. She's the center of attention, so yeah. Chatting up and exit him, oh dear. As long as we, no one agrees to play hide and seek with her, we're all right. Come on, Mr. Kranick. You must be ready now. I wonder how long before they quit. Well, Queen Boone. Queen Boone. Let's see if she gets out of this case. Yeah, this is one case that she's not going to be getting out of, I don't think. The poor guy keeps giving her the side eye. Probably nervous. Oh, there he is. I think we're starting. Anytime now. She thinks she's getting out. She does. She sure does. Here we go. Right, I'm going to move out. We got sound in the courtroom. I'll see you on the other side.
William J. for the state.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
I do. Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Copsell and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as one for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as state C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase. Again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent. And she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over. He sticks his fingertips out. She hits him with a bat. So she's now the initial aggressor. And we'll discuss jury instructions as we get closer. But she's the initial aggressor. And she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but
What
that
is it?
has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made, or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, can I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yeah.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279. No argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110. Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724. State v. Woodson, 349 Southern 3rd, 510. And Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in the—
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. the court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law. Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Not from the state. She's allowed to be here to watch. I understand, but I want to know whether she's going to testify. I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Awesome.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No.
law.
The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court for those comments. For them not to put that in there, I disagree with.
Okay, well, the Jackson case speaks for itself and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since
Well,
we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every time.
In 2018?
2008.
I'm talking about the 2018 incident with regard to the plate glass
I have to look
window.
at the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk, or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the depositions read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what I know. You may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. but I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach this for a second?
Hello. Are we done? I missed that last bit. Because I was chatting. I heard, the last thing I heard was a juror's got COVID. So they're going to be a juror down, aren't they? COVID, yeah. Well, we don't want them all getting COVID. So that juror, just leave him at home. We don't need him. He has no idea how she's going to testify. Well, he absolutely should know. I do like this judge. I do like him a lot. He's very fair. I thought I was listening into his commentary, and I found myself nodding along to what he was saying. Is the real word for COVID banned on YouTube? Not as far as I know. I don't think so. 2 jurors with COVID. All right, okay. Isn't there a new variant these days? I caught a little bit of news. There's a new variant that's putting people in the hospital. I don't know whether it's just in this country. They've been incubating it in the jury room. Well,
All right, court's going to take a 15-minute recess
Oh.
to address jury selection location this afternoon. And
15-minute
to give the
recess.
defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct.
I wish these attorneys would stand close to the microphones.
I
because
read you what was provided to me.
You can't hear them half the time.
Okay. Court's going to be in a 15-minute recess. Thank you.
15-minute recess. All right. Well, this is interesting. So we've got 15-minute recess. So I'm going to just go over to MichelleAfterDark and chat a little bit there. So if you're flicking between 2 channels, the court is on a break over in Georgia for the Leilani Simon trial because the judge has to think about something. So she's given them a 15-minute break to think while she can think. So, all right, so I'm going to mute out here and go over there if you're following me around. Hey, I've been ignoring you. I've been talking about psychopathy and bipolar disorder over on the other channel. So I've been ignoring you. But this is a long 15 minutes. It's a long 15 minutes for these judges. You got split screens on with both streams showing. Oh, that's so bad. That's so bad. Yeah, I can imagine how the trial's going to go. Sarah's lawyer has already said he likes to walk around the courtroom. They need to give him a clip-on mic then. Surely they can stretch to that. They're only cheap. He needs a clip-on mic. And then he'll be fine. Because if you turn your volume up, like when an attorney's talking, you turn your volume up, and then the judge comes on and his audio's really loud then. So we need a little bit of stabilization. Where are our blood alcohol levels? Don't know. I don't know. Because it would have been hours later, because she only called the cops at 1 a.m. So she was, 1 p.m. So she was drinking the night before. So you're looking at a maximum, maybe 12, 13, 14 hours previous. So her blood alcohol is going to be, she may not still be totally sober, but her blood alcohol is going to be low. So it wouldn't be a reliable indicator of how much she'd been drinking the night before. I know they can do like calculations. I know they can like do an approximation, but those approximations are pretty bad, honestly. So yeah, they've got more jurors today. Yeah, more jurors today. Following me around. Husband had COVID 2 weeks ago and no one else in the house got it. Some people are immune now. Like they're immune to even the, new variants because they are sufficiently similar to each other that people have got immunity. So if you've had it a few times before, you might be immune to new variants. It doesn't mean to say you're going to be immune to every single new variant, but it's like flu. Like some people have immunity to certain flu strains because they've had a similar flu strain in the past. It's like the common cold, although the common cold is more than one virus creates a common cold. So actually a quarter of people who are suffering from the common cold have a coronavirus, but not the coronavirus that creates COVID-19, the different strain of coronavirus. And then the rest, I think, is adenovirus. You've never got COVID. My mother hasn't never had COVID. And my granddaughter's never had COVID. Like they've had colds, but when they've tested, it's not COVID. So yeah, never had it. I've had it 3 times, I think. I had it once, definitely, for sure. Got long COVID. And then a few months later, I got really ill, but I tested negative. But I think I just tested too soon. I think if I'd tested the day after, I would have been positive. And then I think I had it again, like a 3rd time, when, what was it, Omicron, I think it was called, when that was doing the rounds. I think I had it again, but I didn't even bother going and getting a test. And that was only very mild, and it could have just been a cold. It felt a little bit COVID-y. It felt a little bit worse than a cold, but it could have been just a cold. And then I've never had anything since. So I don't really care. I don't really care now. Right, if I feel ill, I feel ill. I don't see that many people anyway, so never got COVID, no vaccines. My mother gets a vaccine like every time they bring a new one out, she goes and gets it. She's like a sheep. She's like a pincushion. She'll take anything. My granddaughter's only 10. She's not been vaccinated and she's never had it. Only had it once, felt like I've been hit by a truck. Yeah. Yeah. I mean, look, the first time I wasn't that ill. I wasn't that ill. However, I just never got better. And then I just didn't get better. So it developed into long COVID. Don't I have lupus? No, I don't have lupus. I have ME. So whenever I get a virus, my body overreacts anyway. Like I had a sore throat early in September. I got a sore throat for like 24 hours and it took me about 3 weeks to recover. I was just literally sleeping the whole time. All right, Judge back. Judge back. Can you mute out?
We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can you all approach?
Hello. Hello. The judge is back over in Georgia. There, look at Sarah. Look at her. What's she doing? She's like she's preparing for a test.
Both of her attorneys at counsel's table, the attorneys for the state.
Very smug looking, yeah.
We've taken a break on the defense.
All right, I'm going to mute out here because it looks like the judge is going to be back here very shortly. I'm going to mute out here.
All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
All right, guys. I don't know whether we're going to come back to court here. I've no idea. I know that the judge said he was stepping out, but I think the rest is about the jury selection. So I'm going to go ahead and end it here. But if there's anything else, and I'm sure there will be other things that come out later today regarding Boone and the jury selection, which won't be televised. So if we all now hop over to Michelle After Dark, I will chat there about Boone, Simon, and Alan all over there. So I'm going to end this live right here. And I shall see you over on Michelle After Dark. Bye, guys.